Morning. Today we are going to start with the topic stranger to consideration. Okay. In the last lecture we have seen about consideration, definition of consideration and the legal requirements of consideration. What were the legal requirements? Consideration should move from promisor. From the other side it can move from promisee or any other person. It can be past, present or future. It can be doing of an act or it can be abstinence also. Okay, but consideration must be there. What law says? Consideration must be there. It can be inadequate also, means consideration is not required to be adequate. Okay, now but consideration is very much required because law clearly states agreement without consideration is void. It means here the consideration is what? Stranger. See what is the meaning of the statement stranger to consideration? Stranger to consideration means in that agreement consideration is not there. That is, consideration is stranger. Okay, therefore it is called as stranger to consideration, and that agreement is completely void because law declares it. Okay, now the maxim is what? Ex nudo pacto non orita actio. Ex nudo pacto non orita actio. It means an agreement made without consideration is void. Now agreement made without consideration is void. However, there are certain exceptions, and that is mentioned in section 25 and 185 of the Indian Contract Act. Okay. Now what section 25 is telling? Agreement without consideration void. Clear cut. Agreement without consideration void. Unless, so by stating unless, what they are doing, they are creating exception itself. Unless it is in writing and registered, or is a promise to compensate for something done, or is a promise to pay a debt barred by limitation law. So section 25 is clearly stating that agreements without consideration is void. However, there are certain exceptions, and section 185 is there, which also states about exception. Now section 185, that is, it deals with a special type of contract, and that is what? Agency. Okay, now when agent is been appointed, he will do certain things on behalf of the principal. Now that topic is having this section 185, which clearly says consideration not necessary. Section 185, consideration not necessary. No consideration is necessary to create an agency. So agency is also an exception. Now we'll see again the clear concept. Stranger to consideration means in that agreement there is no consideration. It is void. Okay. However, there are certain exceptions. Now what the exceptions are? As per section 25 and section 185. Okay. Now the exception is, first is what? When an agreement is entered into by two parties who are having love and affection, and it is done in writing, it is registered document through natural love and affection, then such an agreement, though without consideration, it is valid. Though without consideration means in such an agreement there is no consideration. Consideration is stranger here. But as law has created an exception, therefore the agreement is valid. It is a contract. In writing, agreement expressed in writing and registered under law, made in account of natural love and affections, parties standing in the near relation to each other, enforceable, though there is no consideration. So this is the first exception. Second is what? Compensation for voluntary services. A person has given some voluntary services to you, and you have not denied it. You have accepted the services. Now if you are accepting the services, then you have to pay for it, isn't it? Because you have taken his services. So when a person gives a voluntary service, if you don't want the service, say no. But you have taken it, you have enjoyed the benefits, then you have to pay him. This is a contract. Therefore the second exception is what? Compensation for voluntary services. Okay, this is the second exception. The third is what? promise to pay a time barred debt. Okay, now law helps the vigilant, the active, not the dormant. Okay, so we are having Limitation Act which provides for limitation period. When you file a case against other, that should be strictly within the limitation period. If the case is outside that time, then the case becomes time barred. The judge will not hear your matter. The matter will be dismissed on the basis of what? Time barred. Your matter is time barred now. So if, like an example, or you can say this exception is what? Time barred debt. A debt is there which is to be recovered, or the person has to file a case in a court from the cause of action within 3 years. 3 years is the limitation period which has been given by the Limitation Act. Now when the person does not file the case within 3 years, his debt, though it was legal, now it is time barred debt. Therefore, he can't recover it from the court. But if the debtor gives a promise to the creditor that he will pay the debt, though it is time barred, such a promise will become a contract, though it is a promise for paying a time barred matter. So there is no consideration here for the other promise, the next promise, not the first debt, the next promise. Then it is a valid contract. Okay, promise to pay a time barred debt is also without consideration, but it is valid. The next is what? Completed gift. Completed gift. When the donee, the person who gives the gift is called as a donor. The person to whom the gift is given is called as a donee. Now the donee has accepted the gift. Once he accepts the gift, it becomes a valid gift. Therefore, it is called as a completed gift. What is a gift? Gift is a voluntary transfer of ownership without consideration, and the donee has accepted it. So the gift is without consideration. We agree for that. The definition of gift itself is what? Voluntary transfer of ownership without consideration. But gifts are valid because it is mentioned in the law that though it is without consideration, it is valid. Charitable endowments. In charitable endowment also, we don't get anything from the other side. We give it without any consideration. But charitable endowments are also valid. So in these section, whatever section 25 is telling, in these exceptions, there is no consideration, but it is a contract. It is enforceable in law. Though without consideration, it is valid. Okay. Now section 185 states about agency. A person, what he can do it for himself, he can do it through another. When he is doing it through another, it means he is a principal and the other person is the agent. Now this agent is going to enter into contract on behalf of the principal. The agent may not take any kind of money or may not take any kind of charges. Actually, agent take their payment for their services. It is allowed, but law says that for creation of agency, there is no need of consideration. It is clearly mentioned in section 185 of the Indian Contract Act. Consideration not necessary for creation of agency. Though consideration is not there, though the agent is taking nothing for his services, for the work done, whatever he has entered into, whatever contract he has entered into, that contract is valid and the principal is going to get bound by that contract. Okay. Now these are the exception to the concept stranger to consideration, or you can say these are the exceptions to the general rule that ex nudo pacto non orita actio, a contract without consideration is void. However, there are certain exceptions. We'll repeat. If the agreement is in writing and registered. Second, compensation for voluntary services. Third, promise to pay a time barred debt. Agency, completed gift. And the last is what? Charitable endowment. If charitable endowments are there, it is without consideration, but all the all the 6 exceptions which I have told you, those are valid contracts. valid contracts. Therefore, they are enforceable in law. Okay, got it? This was a concept of stranger to consideration. Okay, bye bye. See you in the next video.